Hi folks. So in this video I'm going to walk through the process. People ask, how do I file a claim? I have a work injury. What do I do next? So I'm going to walk through basically the life cycle of a claim in the early parts of its days. I'm going to go through what's called a first report of injury. I'm going to go through a BWC order that in this case had denied the claim, and then I'm going to go through the steps that we take to get that to be heard before the Industrial Commission, and then I'm going to walk through the notice that's sent to you, and then I'm also going to walk through the DHO order. In this case, we prevailed, and then the employer, it was on their responsibility to appeal, so I'm going to walk through that. So that's going to be a pretty simple video, but there's probably going to be a lot here, so just bear with me and we'll proceed. Alright, so the first thing that happens is, let's say you're at work, you're lifting pallets, and you're putting pallets from the floor to a shelf, and then in the midst of doing that, you feel a pop or a crack in your back hurts. You tell your supervisor, hey, my back hurts, I don't think I'm going to be able to work anymore, or hey, I've got this ache in my back, it's kind of painful, and your supervisor might suggest, hey, go ahead and go to urgent care or the emergency room, or you might end up finishing the shift, and then you go to the urgent care after your shift, or you work for a week or two, and then after a week or two you're like, this backache's not getting any better, so then you go to the ER, urgent care, your primary care physician, basically any medical provider, and it's usually at the urgent care ER where they'll do this for you. But you're going to go there, and they're going to have you fill out what's called first report of injury, occupational disease, or death form. So it's called a FROI 1, FROI-1. So that's a first report of injury form, and what this will do is you'll fill out the top of the information, or somebody will, with your demographic information, and then in the middle you basically explain when the injury happened, what time, what date, how the injury occurred, and then where you're injured. And the key with these things is you gotta, if you don't sign and date it, they might not process your claim. The claim rep might insist that you sign and date it. I had somebody submit an electronically signed version of this, so they did it on the computer because there's a form on the BWC site where it allows you to do so, but they wouldn't accept that. So where it says injured worker signature, you sign and then you date that, and you can put your telephone number, work number if you want. That's not so important. And then the treatment info is not what you fill out. That's what whoever you're going to see, the medical provider. So that's either your, again, ER, urgent care, your primary care physician, or a BWC certified doctor. And then finally, there's the employer info at the bottom. Again, you're not going to fill that out. So the things you're going to fill out are at the top. And you could, if all you have is just the thing filled out at the top, your section, that's fine. That's good enough to get the claim started. So, but remember, sign, date, it's important, and then have the information be accurate, particularly the date of injury. We could fix these date of injuries later on, but it can cause problems, particularly if you're injured in 1 week, and then you're claiming you're injured a week later, and the employer gets medical documentation that shows in fact that the injury happened and the date that it actually happened, not the date that you thought it happened. And they'll be like, well, this is clearly an unrelated work injury, and then you have to go to a hearing. You have to say, actually, it's the same injury. My date was wrong. I was off a week, etc. And a lot of times that'll fly, but sometimes it won't, and so that could kill your claim right there. So that's the FROI. So this gets the claim started. So the next step is the BWC. They're going to gather the medical records. Medical records are huge in BWC things. So they're going to go gather the medical records, they're going to review them, and then the next thing they're going to do is they're either going to issue a BWC order allowing the claim or denying the claim. So that's what I'm going to go talk about next. So this is just the first report of injury. Alright, so if we go back to the FROI, this injury happened apparently in November of 2017 or thereabouts. So then the claim was submitted to the BWC, I believe, through the ER. BWC had a file review. It's called a physician review by this Dr. Yasowitz fellow, and that, based upon the file review, the BWC did not support the allowance of this claim, and they indicate the condition that the ER diagnosed. So this claim is not allowed at this time. and the key thing you got to look at here is it says you have 14 days from the receipt of this order to file an appeal. So you got to file it within 14 days, and usually they say 14 plus 4, so 18 days, 4 for mailing. But all these time limits on all these are very important. You got to really keep on top of that. And again, this is one of the big reasons, or one of many big reasons why it's best to get an attorney involved, because we're on top of these dates, whereas somebody who lives a normal life, who's not always cognizant of these dates, they can let these overflow, and if they go past, then you might be stuck. Your claim is allowed or is not allowed. This order stands, and if you hadn't appealed it within that 14 days or 18, you could be stuck and may not have any additional remedies. You'd be stuck paying for your own medical bills possibly, and then you would be stuck not being entitled to receiving compensation or whatever. So in this case, we got this order and we appealed it. So, and what we do is we appeal it. It's called an IC-12 form, I believe. But irregardless, you appeal on the Industrial Commission. We do it online. If you don't have a Social Security number, some people don't, you have to hand fill this form out and then hand it into the Industrial Commission. But we received it on December 29th, or rather December 30th, and then appeal was given to the employer and on January 8th, 2018. So we appealed this BWC order, and so the next step after that is it's going to go from the BWC's hands to the Industrial Commission. So you're going to have a hearing before the Industrial Commission. So that's what we'll be talking about next. Alright, so you had your first report of injury. BWC, whenever they did a file review in this case, they found that the claim wasn't supported. We appealed that BWC order denying the claim, and so then it was referred to the Industrial Commission. So these are two entities. They sound like the same thing. And the BWC, the Bureau of Workers' Comp, is separate from the Industrial Commission. The Industrial Commission decides things essentially. So when there's a dispute. So in this case, there's a dispute. We want to be allowed the claim. So we file the appeal, and then what's going to happen is you're going to get what's called a notice of hearing in your mail, as long as your address is correct. If you've not given the correct address or your mail is wonky, you may not get the notice of this hearing. If you fail to go to the hearing because of your mail wasn't delivered correctly, or some people's mail is stolen, there's remedies to that. If there's a hearing, you don't show up because of that reason. But a lot of times if you're represented, your attorney is going to call you anyways and say, hey, especially if it's an important hearing, you got a hearing at such and such date at such and such time, please show up. And if you don't show up, that's maybe you don't care or whatever, but if we're going to call you to have you show up, then it's important that you show up, and then show up on time too. That's the other key. So, and you'll get this notice of hearing. It's going to tell you the address where the hearing is. It's going to tell you the room. It's going to tell you the date and the time, and it's going to tell you what the issue is. So in this case, the issue is the injury or occupational disease allowance. So we're going to be arguing to have the claim allowed. And you should ask your attorney. There's different hearing offices. They may have free parking. Some hearing offices the parking's not an issue. There's plenty of parking at Columbus. It's kind of, there's not free parking around there, but there is for injured workers. So ask your attorney where the injured worker free parking is. Okay. So the next step after you go to the hearing, and we'll talk about how that goes. All right. So you've got the notice. You go to the hearing, and at the hearing, your attorney is going to present whatever the issue is. This is an initial allowance hearing for this individual. So the argument was, hey, this guy was injured. This is how he was injured. This is the medical we're relying upon, and that same medical will indicate what the initial diagnosis we're going to go after. So what conditions we're gonna try to get allowed in the claim, and we might ask, and it might be necessary to ask you, how did you get injured? Were you injured before? Had you injured that body part before? Is there any intervening injuries? Do you have pre-existing conditions in that same body part? The employer's rep may have questions, and the hearing officer may have questions for you. And the other thing we'll ask at these initial allowance hearings is if you're not working because of the work injury and you've been certified off or with restrictions by your doctor and you're not working, we're going to ask that TT be paid during the dates of certification. So if it's a closed period, we'll ask for a closed period. If you're still off, we'll ask that it continue to be paid upon proof of further disability. So in this case, the claim was allowed, and then it looked like it was allowed for basically a neck sprain strain and a trapezius strain. And then they granted comp at this hearing, and so we prevailed. Anytime you prevail, it's awesome. So this person was happy, but you're not over you're not done, because what if you look at at this order, you have again 14 days plus 4 to appeal that. So in this case, we prevailed, so we're not going to appeal something that we prevailed upon, but the employer may. So, and if it's really contentious things, or there's a condition that's really expensive and you prevail at the DHO, the game isn't done until you win at the SHO. So the DHO is kind of practice, but it's also kind of sets the pattern of how things are going to go in the SHO. So if you prevail at the DHO, a lot of times you'll prevail at the SHO, and the tendency is for the hearing officers to affirm the DHO's order. It's not always the case. It could be that the DHO, you or your employer didn't have evidence, and then at the SHO they have new evidence, or they've gotten medical evidence that rebuts whatever you're trying to do. So it could completely change the game. So you could have lost at the DHO and win at the SHO, and likewise won at the DHO and lose at the SHO. So in this case, we prevailed at the DHO. We're not going to appeal. It's the employer's. It's on their, shoulder whether they want to appeal or not. And so they did. So they filed this IC-12 online again, and so what that would do, what that triggers, is another hearing. So it starts a cycle again. You get a notice, and then there's going to be an SHO hearing, and likely, if that happens, you're probably going to be arguing over the same things, but you're going to have a completely different hearing officer. That could be good or bad. If you had a really conservative hearing officer, really employer-centric hearing officer at the DHO, it could be good, because at the SHO you might get a more reasonable hearing officer, or you could get a really conservative hearing officer. But in this case, the employer appealed, and then they withdrew their appeal, so there wasn't an SHO hearing. So this person's claim remained allowed for the conditions that were requested in the DHO order. So that is the basic steps, or what you might go through initially with your workers' comp claim. But as you can see, there's a lot of paperwork. It's not necessarily rocket science, but there's a lot of appeals periods. There's a lot of specific documents you have to submit. So as I say in every one of these videos, if you have a work injury that involves more than like a 2-day thing where you shake it off and you go back to work without any issues. It really benefits you to hire a workers' comp attorney. And plaintiffs' attorneys work on contingency fee basis, unlike employers' attorneys who work on hourly fee basis. And what that means is, it's the old saying, we don't get paid unless you get paid. So if we spend hundreds of hours on your claim and we don't prevail in getting any money, likely you're not going to pay us anything. If we've spent money on like a doctor's report or something, that might be an expense in your claim, but usually most attorneys are going to let you know, hey, there's an expense that we're going to possibly charge you. Do you want us to pull the trigger on this? So, but that's it. If you have any questions, you could email me, and I'll try to answer them to the extent that I'm allowed to. We're not, since there's no attorney-client relationship, we're not allowed to dispense legal information. But if I can help you, I will. And again, I recommend, there's a lot of good workers' comp attorneys in Ohio. So get a workers' comp attorney. Obviously, you're watching this video. This is Malek and Malek, so we'd prefer you come to us. But I just want you to get help. This process is complicated enough. So thanks for bearing with me and listening to this video. And hopefully you've learned something helpful. Thanks.